Wendell, stop right there and place the case files on the bench.
My clients are waiting inside.
Another attorney will meet with them.
What's this concerning?
For years, people trusted Wendell Carr with the one thing they couldn't afford to lose: their freedom. Every single one of them was wronged too.
Your financial dealings with third parties?
I'll cooperate.
He would not be allowed to finish that sentence. Within 90 days, federal prosecutors would unseal a 31-count indictment, alleging that for the better part of 7 years, Wendell Carr had been collecting envelopes of cash from the very people his own clients were trying to fight. Bribery, honest services fraud, obstruction of justice, 90 months in federal prison, immediate disbarment, and 147 convictions, each one earned through his advice, now flagged for review by a court that no longer trusted a single word of it. Before we go any further, I have to ask you something. Have you ever sat across from a professional who was supposed to be on your side and wondered, for just a second, whose side they were actually on? Doctor, lawyer, accountant, drop that story in the comments. And if you are new here, subscribe. This channel exists to make sure that people who weaponize public trust have to answer for it in front of an audience that refuses to look away. Wendell Allen Carr was born on March 11, 1970, in a 2-bedroom rental house on the east side of Belmore County, in a small mill town called Faircrest. His father, Allen Carr, worked the second shift at the Faircrest Paper Company for 31 years. His mother, Loretta, kept the books at a feed and grain co-op on Route 9 and took in mending 3 nights a week to cover the property tax bill. The family was not poor by Faircrest standards. They were tight. There was always food on the table, and there was rarely anything left over at the end of the month. Wendell was the middle of 3 children. His older sister, Diane, would eventually become a school nurse. His younger brother, Roger, joined the Navy at 17 and stayed in for 20. Wendell was the reader. Teachers at Faircrest Elementary noted it in writing as early as 2nd grade. Verbally precocious, one report card said. Capable of explaining the rules of any game to the other children, and willing to do so at length. By 4th grade, he was working through the World Book Encyclopedia, volume by volume on Saturday mornings, sprawled across the linoleum in front of an oscillating metal fan. In high school, he found debate. Belmore Central had a small team that traveled to maybe 4 tournaments a year in a 15-passenger van borrowed from the Methodist Church. Wendell took to it the way some kids take to football. He won the regional Lincoln-Douglas bracket as a junior, arguing the affirmative on a resolution about mandatory minimum sentencing. He won it again as a senior, arguing the negative on the same topic. His coach, a social studies teacher named Mr. Petrowski, told the local paper that Wendell could talk a jury into anything if he ever decided to point that ability somewhere useful. He graduated 14th in a class of 182. He accepted a partial scholarship to the State University, 2.5 hours east of Faircrest. He worked the dish line at the dining commons 16 hours a week to cover the gap. He majored in political science and minored in philosophy. His professors remembered him as quiet, prepared, and stubborn in seminar discussions when he believed he was right. Law school came next. He sat for the LSAT in October of his senior year, scored a 163, and was admitted to a respected regional law school on a partial merit award. He took out $41,000 in loans across 3 years and graduated in May of 1995, ranked in the top third of his class. He had options. A mid-sized civil firm in the state capital offered him $52,000 a year to start. An insurance defense shop in a neighboring city offered $57,000. He turned them both down. In a letter to his father that Allen Carr would keep in a manila folder for the rest of his life, Wendell wrote, "I did not go to law school to keep insurance companies from paying claims. I went so I could be the person standing next to someone when nobody else will." He applied to the Belmore County Public Defender's Office in June of 1995. His starting salary was $31,200. The orientation was 40 minutes long. His first caseload was 37 open files. For the first 9 years of his career, Wendell Carr was, by every available measure, the kind of public defender his clients needed him to be. His evaluations from those years read like recruiting brochures. Tireless, tenacious, refuses to plead a client who has a defense, files everything. A supervising attorney in 2001 wrote that Carr was the only lawyer in this office who reads the discovery before the first appearance, every single time, without exception. He married Caroline Vance, a paralegal at a small estate firm, in the spring of 1999. They bought a 3-bedroom Craftsman on Pender Avenue in 2002 with a 30-year mortgage and a screened back porch that looked out over a fenced yard with a maple tree in the corner. Their daughter Hannah was born in 2003. Their son Eli was born in 2006. He coached Eli's little league team for 4 seasons. He drove Hannah to swim meets at 5 in the morning. He owned a 2004 Honda Accord with 212,000 miles on it because the car payment was the line item he could most easily kill when the family budget got tight. That was the man. That was who Wendell Carr was for almost a decade in a job that does not get easier with time. To understand what Wendell Carr would eventually do, you have to understand the position he occupied, because the office of the public defender is not just a job. It is, on paper, the entire reason the American criminal system claims to be fair. When a person is arrested in Belmore County and cannot afford an attorney, the court appoints one for them at no cost. That appointed lawyer comes from the Belmore County Public Defender's Office, a staff of 14 attorneys, 4 investigators, and 6 administrative employees housed on the 3rd floor of the Belmore County Justice Center on West Marlin Street. The office handles roughly 2,200 felony cases and 4,500 misdemeanors per year. The vast majority of those clients have a high school education or less. Roughly a third cannot read at an 8th grade level. About 1 in 5 has a documented mental health diagnosis. Most of them have never spoken to a lawyer in their lives. The system is designed around a single, fragile assumption. The assumption is this: when the prosecutor stands up and accuses a defendant of a crime, there will be another lawyer in the room whose only job, whose entire professional and ethical obligation, is to fight back on that defendant's behalf. To read the police reports, to challenge the warrant, to file the motion to suppress, to investigate the witness, to, if necessary, take the case to trial in front of 12 strangers. The defendant does not have to be smart. The defendant does not have to be educated. The defendant does not have to understand the rules of evidence, or the elements of the charge, or the difference between probable cause and reasonable suspicion. They only have to trust their lawyer. That trust is the entire system. Pull it out, and the whole thing collapses. Public defenders are evaluated, when they are evaluated at all, on caseload management and disposition rates, not on outcomes, not on motions filed, not on hours per case. The supervisors who review files are themselves drowning in cases. The judges who oversee the docket are paid to keep that docket moving, not to second-guess the strategic decisions of appointed counsel. The clients have no way to compare. They have never had a private lawyer. They do not know what one looks like. If a public defender tells a 19-year-old high school dropout charged with possession, with intent that the prosecutor is offering 36 months, that this is a good deal, and that he should take it because trial could mean 10 years, that 19-year-old has exactly one option. He has to believe his lawyer. He cannot Google the case law. He cannot call a second opinion. He cannot fire his lawyer and hire someone else because he has no money. He can refuse the plea and demand trial, but his lawyer is the one who will be trying it. Refusing the plea means betting his entire future on a person he is no longer sure is telling him the truth. So, he signs. He takes the deal, and the system records it as justice. The first envelope arrived in the summer of 2017. By that point, Wendell Carr was 47 years old. He had been a public defender for 22 years. He had been promoted twice, was earning $84,000 a year, and was supervising 3 junior attorneys. The mortgage on Pender Avenue had 11 years left on it. Hannah was a sophomore at the State University with a partial scholarship and $28,000 in unmet need. Eli was 11 and had just been diagnosed with a learning disability that the school district was not legally required to accommodate. The Accord had been replaced with a used Toyota Sienna in 2014. Caroline had taken a second part-time job doing intake at a dental office. None of it was breaking the family. All of it was grinding them. The case was State v's Renfro. Tyrell Renfro, age 20, was charged as one of 4 co-defendants in an armed robbery of a check-cashing storefront on Highway 11. Renfro was the youngest. He had no prior felonies. He was, according to the discovery, the one who had waited in the car. He had been assigned to Wendell Carr. The lead defendant in that case, a 34-year-old named Dwayne Hollis, was represented by a private attorney out of the state capitol. Hollis had a serious prior. His exposure was significant. If Renfro flipped, if Renfro cooperated, Hollis was looking at 20-plus years on the federal handoff. In late June of 2017, Hollis's private attorney made an approach. Investigators would later reconstruct it almost word for word from text messages on a burner phone. The pitch was simple. Renfro pleads first. Renfro pleads to the full robbery count with no cooperation provision. Renfro takes 96 months. In exchange, an envelope containing $12,000 in cash delivered to a P.O. box in a town 40 minutes north of Faircrest. The box registered to a paralegal who worked weekends at Hollis's lawyer's firm. Wendell Carr said yes. He told investigators later that he sat in his Sienna in the parking lot of a Dollar General for 40 minutes before he made the call. He said he thought about Hannah's tuition bill. He said he thought about a roof estimate on the Craftsman that had come in at $19,000. He said he told himself, the first time, that Tyrell Renfro was probably going to take 96 months anyway, that he was probably guilty, that this would not actually change the outcome of the case. He said the lie out loud, alone, in a parked minivan, until he believed it enough to dial the number. The method, once he committed to it, was almost insultingly simple. He never filed a motion to suppress the eyewitness identification, which was a show up at the scene at 2:30 in the morning with one suspect in handcuffs in front of the headlights of a patrol car. He never deposed the witness. He never requested the surveillance footage from the gas station across the street, which a later attorney would obtain, and which would show that Tyrell Renfro had been in the back seat of the car for 37 minutes before the robbery, asleep. He told Renfro the case was unwinnable. He told Renfro the prosecutor was being reasonable. He told Renfro that 96 months with credit for time served and good behavior could come down to 70. Tyrell Renfro pleaded guilty on October 19, 2017. The envelope arrived at the P.O. box 8 days later. After that, it got easier. That is what Carr told the agents during his proffer. He used the word easier 3 times in the same paragraph of his statement. After the first one, the calculus shifted. He had already done it. He had already been the kind of lawyer who would do it. The line was not in front of him anymore. It was behind him. The second case came 11 months later. A juvenile transfer matter where the co-defendant had retained counsel paid for by a family construction business with reason to keep the older defendant out of a state facility. $8,000. The third case came 3 months after that, $6,000. The fourth, $22,000. The fifth, $11,000. By the fall of 2022, investigators would document 14 separate cases over a 6-year period in which Wendell Carr accepted payments from third parties to steer his own clients toward losing dispositions. The total cash, traced through deposits in increments small enough to avoid currency transaction reports, came to $131,400. In every single one of those cases, the client signed a plea agreement. In every single one of those cases, the client believed they were being represented. The case that ended Wendell Carr's career was not one of the dramatic ones. It was not the armed robbery. It was not the juvenile transfer. It was a possession with intent case that should have taken 6 hours of attorney time, and that took, in Carr's hands, almost none. The client was a 23-year-old named Marcus Lyle Thompson, arrested in November of 2021 in a traffic stop on Bender Road just outside Faircrest. The stop was initiated for a broken brake light. The officer claimed to have smelled marijuana. The vehicle was searched. Approximately 400 grams of cocaine were recovered from a backpack in the rear footwell. Marcus Thompson was charged with possession with intent to distribute. Thompson had no prior felonies. He had a job at a tire shop on the south end of Faircrest. He insisted from the first interview that the backpack was not his, that it belonged to a passenger who had been dropped off 40 minutes before the stop, and that the officer's affidavit on the smell of marijuana was a lie. Marcus Thompson did not smoke. He had not used cannabis in the 2 years since his older brother died of an overdose. In a normal case, even a moderately competent public defender would have filed a motion to suppress challenging the basis for the search. They would have requested the dash cam. They would have subpoenaed the cell phone records to establish the presence of the third passenger. They would have argued, at minimum, that the 400 grams could not be attributed to Marcus Thompson without evidence of knowing possession. Wendell Carr filed nothing. He requested nothing. He told Marcus Thompson that the case was clean, that the search was good, that the prosecutor was offering 60 months, and that the next offer would be 90. Marcus Thompson pleaded guilty on February 4, 2022. He was sentenced to 54 months in state custody. The payment to Wendell Carr, $14,000 routed through a Shell LLC, controlled by a regional supplier who had a vested interest in Marcus Thompson not cooperating with the state, arrived in increments over the following 6 weeks. Marcus Thompson did not understand what had happened to him, but his mother, a 51-year-old certified nursing assistant named Yvette Thompson, did not stop asking questions. She wrote letters. She called the public defender's office. She drove 4 hours one way to visit her son at a state facility every other weekend. Through one of those visits, she learned about a nonprofit reentry organization that ran a small post-conviction review program staffed by volunteer attorneys. In June of 2023, 16 months after the plea, that organization assigned a young attorney named Janelle Pritchard to look at the Thompson file. Janelle Pritchard had been practicing for less than 4 years. She had clerked for a federal judge. She read the discovery in 3 hours. She read the motion docket in approximately 90 seconds because there was nothing in it. By the end of that day, she had a list of 7 motions that any competent attorney would have filed. By the end of the week, she had pulled the dash cam, the cell tower records, and the body cam from the arresting officer, none of which had ever been requested by the defense. The dash cam showed the traffic stop. It showed the officer approaching the window. It showed, audibly, the officer saying to his partner, "I'm going to say I smelled weed," before he ever spoke to Marcus Thompson. Janelle Pritchard sat in her car in the parking lot of the state correctional facility after her first meeting with Marcus Thompson, and she did not move for almost an hour. Then she drove back to her office and pulled every single criminal case Wendell Carr had handled in the previous 7 years. What Janelle Pritchard found, she did not find alone. She found enough to walk into the United States Attorney's Office for the relevant federal district in October of 2023 and request a meeting. The meeting lasted 40 minutes. She walked out with the personal cell phone number of an assistant U.S. attorney named David Rosenthal and a written assurance that her client's file would be opened as part of a broader inquiry. That broader inquiry was assigned to the FBI's Public Corruption Squad in the regional field office. The lead agent was a 14-year veteran named Brett Calloway. He pulled Wendell Carr's financial records under federal subpoena in November. The deposits were not hidden well. They were structured, which is itself a federal crime, but they were structured by a man who had read about structuring in case files and who had no actual experience executing it. Cash deposits in amounts ranging from $1,600 to $8,900, made at 4 different branches of 2 different banks, spaced out across days that, when overlaid against the court docket, lined up with the disposition dates of his client's cases in a way that no reasonable juror could ignore. Agents pulled the case files for every disposition that matched a deposit. There were 14. In every single one of them, the same pattern: no motions filed, no depositions taken, no expert witnesses retained, no surveillance footage requested, quick pleas, stipulated facts, clients who later, when interviewed by FBI agents in prison, said almost identical things. He told me it was the best I could get. He said the prosecutor would go higher if I fought it. He said the judge would punish me for going to trial. Agents pulled the records of opposing counsel. They cross-referenced the payments. In 9 of the 14 cases, the funds could be traced directly or through a single intermediary to a person who had a direct interest in the outcome of Wendell Carr's client's plea. A co-defendant, a co-defendant's employer. In one case, a regional drug supplier operating through a paper company that listed its principal address as a UPS store. The smoking gun, in the end, was not exotic. It was a spreadsheet that Agent Calloway built in Microsoft Excel. 2 columns. The left column was a list of plea dates for Wendell Carr's clients on the 14 flagged cases. The right column was a list of deposit dates in Wendell Carr's personal and joint accounts. The dates matched, almost without exception, within 5 business days. The text messages were worse. Agents recovered a burner phone from a storage unit Carr had been renting under his late father-in-law's name in a town 20 miles south of Faircrest. The phone contained, among other things, the following exchange with Dwayne Hollis's private attorney from September of 2017. The attorney, on September 6th, wrote, "Confirm Renfro takes the deal Thursday." Carr responded, "Confirmed. No suppression. No witnesses called. He believes it." The attorney wrote back, "Box Tuesday." Carr's reply was a single word, "Understood." In another exchange from 2020, with a different intermediary in a different case, Carr was asked whether his client had any issues with the proposed plea. Carr's response read, verbatim, "He has no idea what a motion is. He'll sign whatever I put in front of him." That message was sent at 11:42 on a Tuesday morning. According to court records, Wendell Carr was, at that exact moment, sitting next to his client in a courtroom on the 4th floor of the Belmore County Justice Center. We are about to walk into a federal courtroom, and I want you here for it. If you have made it this far, you already understand why this case matters more than most. Subscribe before we go in. These are the stories that almost never get told properly, and that is what this channel is built to fix. The arrest happened at 6:51 on the morning of January 9th, 2024. Wendell Carr was already up. He was almost always up by 5:45. He had made coffee in the stained Cuisinart on the counter of his kitchen on Pender Avenue. He had read the front section of the regional paper at the table by the window. He had put on a charcoal suit, a white shirt, and a navy tie with small gold dots. He was standing at the front closet, putting on his overcoat, when the knock came. There were 6 federal agents in his front yard. There were 3 more in the alley behind the house. There was a forensic accountant in an unmarked sedan at the end of the block with a laptop open on her knees. Caroline Carr was upstairs in the bathroom and would not come down until 2 of the agents identified themselves and showed her the warrant through the screen door. Brett Calloway was the agent on the porch. Calloway said, "Mr. Carr, I have a federal warrant for your arrest. The charges are bribery, honest services fraud, and obstruction of justice. Step out onto the porch, please. Hands where I can see them." Wendell Carr did not say anything at first. He looked down at the overcoat in his hand. He looked back up at Calloway. He said, very quietly, "Can I put this down?" Calloway said, "Set it on the bench right there, sir." Slowly, Carr set the overcoat on the wooden bench inside the door. He stepped out onto the porch. He turned around. He put his hands behind his back without being asked. Calloway said, "Mr. Carr, I have to read you your rights. Do you understand?" Carr said, "I understand." He was a lawyer. He had read those rights to clients in interview rooms, in lockups, in courthouse hallways, more times than he could count. He had explained, in plain English, what each sentence meant to clients who could not read, to clients who did not speak fluent English, to clients who were 17 years old and had never been arrested before. He stood on his own front porch in handcuffs, and he listened to the words like he had never heard them before. When Calloway finished, he said, "Do you have anything you want to say?" Wendell Carr looked across the yard at the magnolia tree his wife had planted in 2009. He looked at it for what the body cam timestamp would later show was 11 seconds. Then he said, "I'd like to call my attorney." That was the last full sentence he would speak as a free man. The indictment was unsealed at 1:15 that afternoon. It ran 31 counts across 43 pages. Bribery, honest services wire fraud, honest services mail fraud, obstruction of justice, conspiracy. The factual section laid out 14 cases by client initials, deposit amounts, dates, and corresponding court actions, or more accurately, the absence of them. Wendell Carr's defense attorney, a respected white-collar lawyer named Howard Greenberg, met with him in a federal holding facility that evening. The conversation lasted approximately 40 minutes. Greenberg, who had represented 2 former state legislators and a sitting county commissioner, told reporters later, "There was nothing to negotiate from. The financial evidence was complete. The text messages were complete." The client wanted to take responsibility. Wendell Carr pleaded guilty on March 18, 2024, to 1 count of bribery, 3 counts of honest services fraud, and 1 count of obstruction of justice. The plea agreement contained no cooperation provision. There were no other targets. The corruption, in the end, was his alone. Sentencing was held on July 22, 2024, in front of the Honorable Marion Eastwood, United States District Judge. The hearing lasted 3 hours and 20 minutes. 11 victim impact statements were read into the record, 4 by clients still incarcerated and read on their behalf by family members or by Janelle Pritchard. Marcus Thompson's mother read hers from a single sheet of notebook paper. She said, "My son trusted that man. My son was 19 when he met him and 23 when that man told him to sign. My son sat in a cell for 18 months, thinking he had done what his lawyer told him to do because his lawyer knew best. He did not know that his lawyer had been paid to bury him. He found out by accident. There are people sitting in prisons today who will never find out. They will serve their time believing the system worked the way it was supposed to. It did not work. He broke it on purpose. I want him to hear me say that out loud." Judge Eastwood spoke for 19 minutes before pronouncing sentence. The transcript would be quoted in legal ethics seminars for years afterward. She said, in part, "There is no closer relationship of trust in the criminal justice system that this court has the privilege to oversee than the relationship between an indigent defendant and the lawyer appointed to defend them. That defendant has nothing. He has no resources, no expertise, no second opinion, no one to ask. He has, by constitutional design, one person standing between him and the full weight of the government. That person, by oath, belongs to him." Mr. Carr did not just betray his individual clients. He sold the entire promise of the Sixth Amendment on 14 separate occasions that this court can document to the very people his clients were trying to defend themselves against. He took their money. He cashed their checks. He went home to a house his clients' suffering helped pay for. And then he sat next to those clients in this courthouse, and he advised them, in their own confidence, to surrender. I have presided over public corruption cases involving elected officials, sworn officers, and senior administrators. I have never sentenced a defendant whose conduct represented a more fundamental betrayal of the system this court is asked to administer. I find no remorse in this record that meaningfully precedes his arrest. I find no evidence that he would have stopped on his own. She sentenced him to 90 months in federal prison. She ordered restitution in the amount of $131,400. She referred the matter to the state bar for immediate disbarment, which was effectuated 4 days later. She entered a separate order directing the chief judge of the relevant state circuit to convene a panel for the review of every plea entered by a client of Wendell Carr during the period of the conduct, a process that affected 147 convictions, and that is, as of this filming, still ongoing. Wendell Carr was transferred 2 weeks later to a federal correctional institution of low security designation in a state several hundred miles from his family. His earliest projected release date is in 2031. he will be 61 years old. The license he spent 3 years and $41,000 in loans to obtain has been permanently revoked. The clients he was paid to bury are, one by one, beginning to come home. This case was disturbing. But the case on the right-hand side might be the most unforgivable betrayal of public trust this channel has ever covered. Click it now.